Okay, let's jump right in. Welcome to This Explainer. Today, we're diving into a topic that affects almost every single working adult, but it's completely surrounded by myths. We're talking about your rights and remedies when it comes to wrongful termination. Look, losing a job is incredibly tough, but sitting there wondering if your employer actually broke the law to do it, that's even worse. So let's figure out exactly where you stand.
Here's our roadmap for today. We're going to cover the wrongful termination myth, explain at-will employment, look at forbidden motives, how to prove the real reason you were fired, the process of filing a discrimination charge, and finally, remedies and damages.
Number 1, the wrongful termination myth. Let's start by shattering a massive illusion and looking at the absolute biggest misconception people have about being fired.
Millions of Americans type this exact question into search bars every single year, usually sitting in their car in the parking lot right after being let go. Well, the uncomfortable truth here is that most of them don't actually have a case. You see, the word wrongful in everyday English kind of sounds like it just means unfair, but in the eyes of the law, it means something very, very specific.
An unfair firing is not the same thing as a wrongful termination under the law. Being fired out of the blue by an angry, incompetent manager with absolutely no prior warning, that is unfair. It's totally infuriating, and honestly, it's almost always completely legal. Wrongful termination only happens when you're fired for a reason the law expressly forbids, like discrimination or retaliation.
So the crucial point is that if you get passed over for the boss's best friend or fired over some petty workplace conflict, it's frustrating, but it's legal. The law literally does not exist to referee bad management or fix a toxic workplace. It polices forbidden motives. The question you need to ask yourself isn't, was this fair, but rather, can I connect this firing to something the law forbids?
2. At-will employment explained. To really understand why unfair firings are legal, we've got to look at the bedrock rule of the American workplace. This is fascinating because your physical location heavily dictates your rights. 49 states operate on at-will principles, but the exceptions are all over the map. In strict states like Florida, Georgia, Louisiana, and Rhode Island, employers have massive leeway. Now, states like California and Massachusetts do recognize some common law exceptions, like implied contracts or a duty of good faith. But Montana stands completely alone. It's the only state that rejected pure at-will employment by statute. If you're past a default 12-month probation period there, your boss actually needs good cause to fire you.
In a true at-will state, an employer doesn't have to give you advance notice, severance, or even an explanation to let you go legally. A wild situation for a lot of people is getting fired the absolute second they give their 2 weeks notice. We often think offering notice protects us or is just the polite thing to do, but an employer is totally within their rights to just accept your resignation right on the spot.
3. The forbidden motives. Let's move to the exceptions and see exactly how federal law puts up some guardrails to stop employers in their tracks.
If your firing is motivated by any of these items, it instantly crosses the line from a legal at-will firing into a wrongful termination. It is illegal to be fired based on your race, color, national origin, religion, sex, including pregnancy, age if you're 40 or older, or a disability or genetic information. Plus, you absolutely cannot be fired in retaliation for reporting illegal activity, whistleblowing on safety violations, or taking protected leave like FMLA or jury day.
Also, keep this in mind. If your employer makes your working conditions so unbelievably hostile that you're literally forced to quit, the law calls that constructive discharge, and it treats it exactly the same as being fired. But the bar here is super high. Just having a rough month or an annoying boss won't cut it. The environment has to be so completely intolerable due to illegal harassment, discrimination, or retaliation that any reasonable person would feel they had zero choice but to leave.
4. Proving the real reason. Since no employer is ever going to just come out and admit they fired you for a forbidden reason, we need to know how to catch them in a lie.
Courts look for these telltale signs of pretext. Basically, evidence that the official reason for your termination, like restructuring or poor performance, was just a cover story. Did HR tell you it was performance, but then tell the unemployment office it was misconduct? That's a shifting story. Did you have perfect reviews for 5 years, but then suddenly get written up twice right after you announced a pregnancy? Super suspicious timing. Or what if a coworker who isn't in your protected group made the exact same mistake you did, but they kept their job? That's called a comparator. Or maybe the company just completely skipped their own disciplinary process. These are the tells.
To actually prove your case, you've got to build a bulletproof paper trail, and you need to do it the minute you suspect foul play.
Save your employment records, document all the termination details and any shifting reasons, collect emails that show bias or retaliation, and gather witness statements from coworkers. The more concrete evidence you get, the harder it is for an employer to hide behind that classic excuse of, they just weren't a culture fit.
5. Filing a discrimination charge. Once you have your evidence, you're up against a very rigid and honestly unforgiving legal process.
You've really got to feel the urgency on this one. For private employees, you generally have 180 or 300 days to file a charge with the EEOC or your state agency, depending on where you live. Federal employees, you have a shockingly short 45 days. Eventually, if everything moves forward, you might receive a notice of right to sue. Make no mistake, this is not a rejection. It's your golden ticket to court. But the clock starts ticking the second you get it. If you miss that brutal 90-day window to sue, your case is usually gone forever.
6. Remedies and damages. Let's wrap things up by looking at what a winning wrongful termination case actually looks like in real financial terms.
A successful claim usually results in a mix of these damages, which is exactly why settlements can range from a few months' salary to genuinely life-changing money. You could recover back pay for the wages and benefits you lost since a firing, front pay for future earnings while you get back on your feet, and compensatory damages for emotional distress and out-of-pocket harm. If the employer's conduct was malicious, you might even get punitive damages to punish them. And the cherry on top? In most successful discrimination cases, your former employer has to foot the bill for your attorney's fees.
Now, federal law does cap combined compensatory and punitive damages. Depending on the size of the company, that cap ranges from $50,000 for smaller businesses up to $300,000 for massive corporations with over 500 employees. But here's the kicker. Back pay and front pay sit entirely outside of those limits. On top of that, state laws often don't have caps at all. That is how a really strong evidence file, combined with lost income, can result in a massive settlement.
So what will you do if the unthinkable happens and you suddenly lose your job? Will you just assume it's another unfair, at-will firing? Or will you look a little deeper for the pretext tells of a forbidden motive? It's on you to protect your rights and document absolutely everything. And hey, if you found this explainer helpful, share and subscribe out our channel for more.